The House Judiciary Committee has released the entirety of former special counsel Jack Smith's closed-door testimony from earlier this month. The 255-page transcript and 8-plus-hour-long video shows Smith answering questions about his decision to bring charges against the president for allegedly trying to overturn the 2020 election, revealing Smith's plans for a trial and possible additional charges against alleged co-conspirators. Listen.
Our case was built on, frankly, Republicans who put their allegiance to the country before the party. And so the president got information from people he trusted on other issues.
This just happened. A federal court in Minnesota and the House Judiciary Committee in Washington have moved simultaneously in a way that fundamentally changes the trajectory of the current administration. We are looking at a coordinated institutional response that we have not seen in decades. A federal judge has issued an emergency order blocking the administration from destroying or altering any evidence related to the fatal shooting of a civilian by federal agents. At the exact same moment, Congress has released the full unredacted testimony of former special counsel Jack Smith. This is not a coincidence of timing. It is a structural rupture. We are witnessing two separate branches of government locking down the legal record to ensure that evidence of alleged crimes cannot be erased. This establishes a permanent archive of conduct that the president can no longer control. The stakes here are total. This is about whether the institutions of justice can preserve the truth long enough for it to be used. We need to walk through exactly what is happening right now because the details are specific and the implications are severe. Two distinct legal events have occurred at the same time. They look different on the surface, but they are achieving the exact same goal. They are freezing the legal record. They are taking evidence out of the hands of the administration and placing it into a protected status where it cannot be touched, deleted, or hidden. Let's start with the situation in Minnesota. This involves the death of Alex Priddy. He was a 31-year-old ICU nurse. He was also a protester. He was shot and killed by federal agents during an enforcement operation in Minneapolis. The details of the shooting are currently in dispute. The official line from federal authorities is that he was a threat. The accounts from witnesses and family members are that he was protesting peacefully. In a normal situation, an investigation would follow. But this is not a normal situation. Immediately after the shooting, reports began to surface from inside the local agencies. These reports suggested that key evidence was not being handled correctly. There were indications that body camera footage from the federal agents involved was not being secured in the usual manner. There were concerns that surveillance video from the surrounding area was not being collected. Witness statements were reportedly incomplete. At the same time, a jurisdictional fight broke out. Federal authorities wanted to control the investigation entirely. Local state prosecutors wanted to investigate whether a crime had been committed under state law. While this was happening, administration officials began speaking publicly. They described the shooting as justified before the investigation was complete. They blamed the victim. They attempted to restrict outside access to the scene. To a federal judge watching this unfold, this pattern looked like the beginning of a cover-up. The court decided it could not wait for the normal process to play out. The judge issued an emergency preservation order. This is a very serious legal tool. It is not used lightly.
Are still parsing through it, still trying to figure out what stands out. But what do you see so far?
So a lot of it, what we have in here is stuff we knew because Jack Smith did write hundreds of pages of a final report before he left his post as special counsel. One of the biggest things is that he believed he had enough evidence not only to bring charges and to try, but to convict Donald Trump on obstruction of the electoral count on January 6th. That is a very significant point. He also believed he had enough evidence to convict Donald Trump on the classified documents case down in Florida. The other big point I think that is important making here is that he believed that there were multiple people around Donald Trump, and he says he has evidence of this.
The order explicitly bars any administration official or federal agent from destroying, altering, or concealing any evidence related to the shooting of Alex Priddy. It lists specific items that must be kept safe. Body camera footage must be preserved in its original file format. Surveillance tapes must be secured. Forensic evidence from the scene must be logged and protected. Witness statements must be filed. The judge is sending a direct message to the administration. The message is that the court does not trust the executive branch to police itself. The judge is saying that there is a credible risk that evidence will vanish if the court does not intervene. By issuing this order, the judge has taken custody of the truth. If any agent or official deletes a file now, they are not just breaking agency policy, they are committing a crime. They are in contempt of court. This order locks the evidence into the permanent record. It ensures that if a trial happens in 1 year or 5 years, the proof will still exist. Now we need to look at the second event. This is happening in Washington. The House Judiciary Committee has released the full testimony of former special counsel Jack Smith. This is a massive document. It is a 255-page transcript. It covers more than 8 hours of questioning. This testimony took place behind closed doors, but now it is out in the open. It is part of the public record. In this testimony, Jack Smith details exactly what his investigation found. He is not speaking in generalities. He is specific. He states clearly that his office uncovered evidence that a reasonable prosecutor would view as a criminal plot to overturn the 2020 election. He identifies the former president as the person most responsible for the attack on the Capitol on January 6th. Smith walks the committee through the evidence step by step. He discusses the pressure campaigns. He talks about the fake elector scheme in 7 different states. He details the specific phone call to officials in Georgia where the demand was made to find exactly enough votes to flip the state. Smith explains that this was not a request for a recount. It was a demand to manufacture a result. He categorizes this as criminal intent. Crucially, Smith reveals that his case was not built on the testimony of political enemies. It was built on the testimony of Republicans. He explains that the people who provided the most damning evidence were officials who put their loyalty to the country above their loyalty to the party. He outlines how the president received information from trusted advisors, telling him he had lost and chose to ignore it to pursue a fraudulent path. This testimony is now permanent. It does not matter that the specific criminal cases were paused or dropped due to Department of Justice policies regarding sitting presidents. The evidence does not disappear. The witness accounts do not disappear. The documents do not disappear. By releasing this transcript, Congress has created a roadmap. They have laid out the entire case for future prosecutors. When you look at these two events together, you see the pattern. In Minnesota, a judge is locking down video and forensic evidence of a killing. In Washington, Congress is locking down testimonial and documentary evidence of an alleged conspiracy against the government. In both instances, the institutions are acting to preserve the liability of the leader. This is a containment strategy. The legal system is acknowledging that it may not be able to prosecute a sitting president right now, but it is ensuring that the material needed for a prosecution later is safe. They are building a library of evidence. Every time an order like this is issued, another file is added to the library. Every time a transcript is released, another chapter is written. The administration cannot stop this process. They can fight individual subpoenas. They can claim executive privilege. But they cannot force a judge to unissue a preservation order. They cannot force Congress to unrelease a transcript. The record is growing. It is sitting there. It is waiting for the moment when the immunity protections expire. This creates a very specific kind of danger for the administration. It means that they are governing in a glass house. Every action they take is being recorded and filed away. The judge in Minnesota has signaled that the courts are watching the use of force by federal agents. Congress has signaled that they are archiving the abuse of power. The removal of the president is not happening today, but the case for removal is being built piece by piece in real time. The evidence is being handed into the record. It is being protected from destruction. It is being prepared for the future. We need to analyze why this specific combination of events matters so much. It is easy to get lost in the noise of daily political fighting, but what is happening here is structural. It is about the relationship between time and justice. In many political crises, the goal of the person in power is to create a fog. They want to delay investigations until memories fade and documents are lost. They want to create enough chaos that the public moves on. What we are seeing now is the legal system fighting back against that fog. The courts and the committees are acting as archivists. They are saying that memory is not enough. We need hard copies. We need digital files. We need sworn statements. This is a battle over the official history. If we look at history, we can see why this is so critical. In the 1970s, during the Watergate scandal, the turning point was not the break-in itself. It was the existence of the tapes. Once it was known that a recording system existed, the entire battle shifted to the preservation and release of those tapes. The evidence existed in a physical form that could not be denied. Once the courts ordered those tapes to be turned over, the presidency collapsed. The evidence was the gravity that pulled the administration down. We can also look at examples from other countries. In nations where leaders have held power for long periods and used that power to suppress opposition, the transition often happens when the files are opened. In Latin America and parts of Eastern Europe, there were moments when the immunity of the leader evaporated. At that moment, the archives of the secret police or the internal memos of the Justice Ministry became the most dangerous things in the world. Prosecutors did not have to start looking for crimes. The crimes were already documented. They were just waiting in a box. That is the situation forming here. The release of Jack Smith's testimony creates a permanent reference point. It is not just a story in the newspaper. It is a sworn record. Future history books will reference this document. Future trials will enter this document as Exhibit A. It removes the ability of the administration to rewrite the past. They cannot say that didn't happen when the prosecutor who investigated it has laid out the proof in 255 pages of detail. The Minnesota order adds a physical dimension to this. It deals with life and death. When a government uses lethal force against its own citizens, that is the ultimate expression of state power. If that force is used unlawfully, it is a capital crime. By locking down the body camera footage and the forensic data, the judge is preserving the body of the crime. This is different from political maneuvering. This is about murder or manslaughter charges. These are crimes that do not have the same statute of limitations issues as some political offenses. The comparison here is to a mafia trial. In organized crime cases, the government often spends years collecting surveillance. They do not arrest the boss immediately. They let the boss talk. They let the organization operate. They record everything. They build a mountain of evidence that is so high that when the indictment finally comes, there is no defense. The evidence preservation orders we are seeing now are the government building that mountain. There is also an institutional power struggle at play here. The presidency is very powerful, but it is temporary. The courts and the bureaucracy are permanent. Judges serve for life. Career prosecutors serve for decades. They have a longer time horizon than the president. They know that the president will eventually leave office. They are willing to wait. The fear mechanism is usually how a strong leader controls these institutions. They make the judges afraid to rule against them. They make the prosecutors afraid to bring charges. But these recent actions show that the fear is not working. The judge in Minnesota was not afraid to issue an emergency order against the administration. The committee in Congress was not afraid to release the damaging testimony. This suggests that the institutional immune system is kicking in. The people who work in these systems are deciding to follow the rule of law rather than the rule of the leader. This creates a paradox. The administration may feel powerful right now. They may feel like they can do whatever they want. But in reality, they are accumulating debt. Every time they act outside the law, and every time a judge preserves the evidence of that act, they are adding to a debt that will eventually have to be paid. The legal system is keeping a ledger. The concept of the permanent record is the key. In the digital age, it is very hard to truly destroy evidence if a court order is in place. Metadata traces remain. Backups exist. Cloud servers leave footprints. By ordering the preservation of evidence, the judge is triggering a technological net. It means that IT directors, server administrators, and lower-level clerks are now legally bound to save these files. These people are not political appointees. They are workers. They are not going to risk going to prison to delete a file for a politician. They will follow the court order. This bypasses the political loyalty of the top officials. So the analysis leads to one conclusion. The walls are not closing in today, but the materials to build the walls are being stacked up. The administration is surrounded by evidence of its own making. The courts are ensuring that this evidence survives. It is a slow process. It is a quiet process, but it is the most dangerous thing that can happen to a leader who believes they are above the law. The law is writing everything down. We need to look at where this goes next. The consequences of these actions will play out over two different timelines. There is the short term, which is political, and the long term, which is legal. In the short term, over the next few months and leading into the midterm elections, this evidence will be the ammunition for the opposition. The Jack Smith transcript provides a script for political attacks. We will likely see advertisements that quote directly from the testimony They will not use vague language. They will use the specific accusations of criminal intent. The Minnesota case will likely become a rallying point for civil rights arguments. The narrative will be that the administration is lawless and violent and that the only thing holding them back is the court system. We can expect the administration to react with aggression. They will likely attack the judge in Minnesota. They will attack the committee that released the transcript. They will try to discredit the sources. This is a standard defense mechanism. However, because the evidence is locked in the legal record, these attacks will not make the problem go away. The video footage of the shooting will still exist. The transcript will still be on the internet. Looking further ahead, the consequences become much more serious. If the political winds shift and the opposition takes control of Congress, the impeachment process becomes almost automatic. In previous impeachments, the investigation phase took a long time. Investigators had to find out what happened. In this scenario, the investigation is already done. The evidence is already preserved. A new Congress could simply take the Jack Smith file and the Minnesota court files and draft articles of impeachment immediately. They would argue that the facts are already established. The most severe consequence comes when the president leaves office. Whether that is in 2029 or sooner, the moment the immunity of the office is gone, the legal floodgates open. This is where the preservation orders matter the most. A future Department of Justice will not have to wonder if they have a case. They will open the vault and find the case waiting for them. We must also consider the state-level prosecutions. The federal judge in Minnesota is preserving evidence that state prosecutors can use. The president has no power to pardon state crimes. If the local district attorney in Minneapolis decides to bring murder charges against the agents, and by extension conspiracy charges against officials who tried to cover it up, that case will proceed regardless of who is in the White House. The preserved evidence ensures that the state case remains viable. This situation creates a trap for the administration. To govern, they have to take actions. But because they are under such intense scrutiny and because preservation orders are in place, every action is potential evidence. If they try to fire the investigators, that is evidence of obstruction. If they try to pressure the witnesses, that is evidence of tampering. They are in a position where any move they make to protect themselves legally might actually increase their legal exposure. The outlook is sober. We are likely heading toward a massive constitutional collision. The institutions are hoarding evidence for a future conflict. The administration is trying to outrun that evidence. History tells us that eventually the record catches up. The files do not forget. The servers do not forget. And now, thanks to these orders, the legal system will not forget. The removal of the president from power may not happen through a singular dramatic moment today, but the machinery for accountability has been turned on, and it is running in the background, recording every single mistake